fifth edition of the Legal Era's Gennext Counsel Congress and Awards 2016 witnessed strong participation from the legal business community of India and overseas. Held in Mumbai, the event also saw a galaxy of stars from India Inc. at the venue.
I think Legal Era Conference, and especially this annual conclave which is conducted by the organizers, is great. Every lawyer, whether an external law firm or an internal counsel, must attend this because the conclave deals with the current challenges which lawyers face in multi-jurisdictional space, and also how these challenges and risks can be met and mitigated.
I think it's a very, very useful platform for bringing all the legal counsels together, not only from India but internationally. But more importantly, also getting people from the business like me. You know, I'm a business guy, I'm not a legal guy, but bringing in the business perspective on a lot of legal issues that people face in businesses, in corporates, in startups, in listed and unlisted companies.
It gives a very good platform to all of us and to all the lawyers, all the legal consultants of the companies and the firms to learn.
Akriti Raizada Sharma, founder and managing director, ARA Legal Media Group, welcomed the August gathering.
What binds you and us at Legal Era is our passion for law and the rule of law. It is only through such conferences that we as lawyers and legal professionals can come together and discuss the latest trends and overcome challenges while best fulfilling our individual and collective roles.
This was followed by a keynote address on the legal and regulatory outlook by Cyril Schroff, managing partner Cyril Amarchand Mangaldas.
Speak to any board or speak to any chief executive, and I think the number one issue on their mind is legal risk. It's a huge non-productive risk. So I think a deeper question for the legal community to think of is, if this is the number one issue in the world of business, what are we as lawyers doing in order to deal with it? I think we are dealing with probably a bit like blind men in terms of the kind of issues that the legal industry faces, but risk is not one of them. Second, I think, is the geopolitical concerns. I mean, you just have to open a newspaper or look at a TV channel and you can see how much the world is in ferment. Third mega trend, I think, is, as I said with some trepidation, is the decline in the rule of law, and it sort of varies from country to country. Fourth mega trend, I think, and generational change. And the last key trend is, and it's more a question rather than a trend, is our profession really losing its voice? We are sort of being overtaken by public opinion, namely social media. I think it's much easier for social media to influence the outcome on a particular issue than an intellectual argument with a bunch of jurists. Clearly the trend is that we are being converted from a noble profession to a service provider. Thank you.
The guest of honor, Ajay Kumar, Senior Strategic Advisor, Yes Bank India, gave an insightful speech on the global business and investment regime.
The rapidly globalizing economy has changed the way we approach business. Brick and mortar setup have to learn to coexist and sometimes compete with the e-commerce models. Some businesses like banking and financial services have to proactively evolve into brick and mortar model to thrive. In this backdrop, business regulation and the encompassing legislative framework are imperative to support as well as sustain this rapid transformation. An optimum balance is necessary to provide a level playing field, while at the same time not to hinder the spirit of innovation and entrepreneurship.
And then it was time for the chief guest of the day, Justice Mohit Shah, former Chief Justice of the Bombay High Court, to address the gathering on business leadership and law.
Business always requires an appropriate legal environment to grow and prosper. Therefore, it is high time that at conferences like this, we take up these topics not only of business and law, but what is missing in both the leadership part of it. Recently, I had an occasion to deal with the insider trading regulations framed by SEBI here, the regulatory agency in India. I was very happy to read those new regulations framed in the year 2015 because along with the regulations, they also gave the notes explaining what is the intent of the regulation making authority. Otherwise, we all know that lawyers and judges get lost in the debates on the interpretation of various phrases in statutory provisions or statutory regulations. Therefore, what I want to impress upon the business community and the lawyers as well is that it is very high time that we take up all the necessary steps to impress upon the political executive to see to it that the civil servants, the bureaucrats with whom people have to deal with and common people have to deal with on day-to-day basis, they change their attitude, change their mentality. Thank you for giving me this opportunity.
The inaugural session drew to a close with a vote of thanks by Robert Wild, partner Johnson Winter and Slattery.
I was wondering what a peripatetic lawyer from Australia might say to this audience after listening to these three speeches. And it occurred to me, listening to them, that they all talk about one thing in different ways from different experiences, and it is about behaviour. It is about how we act as individuals, how we act as lawyers, both providing a legal service and hopefully providing a sense of moral balance and a compass in a direction that our client not only wants to go, but perhaps ultimately should go. Thank you, ladies and gentlemen.
The struggle to combat corruption is proving to be one of the most important global challenges. The panelists in one of the sessions of the Legal Era's Gennext Counsel Congress and Awards 2016 dwelled on the theme of tackling the menace of corruption, look at the worldwide anti-corruption legislation and beyond.
I first invite Mr. Ogundepe to say a few words in respect of his experience.
Nigeria, where I come from, when we talk about grand corruption, it's not an issue of people taking bribes and things of that nature. I view it as pillaging because they don't actually take money for stuff. They just find themselves in a position of power, see a pot of money in front of them, and they help themselves to this. The only opportunity you will have to attack people like this is when they fall from power. The people against whom action is taken, it's the same mantra. In Nigeria, you hear it. In Ghana, you hear it. In Senegal, you hear it. It's always the same thing. It's political persecution. That's what gets into the media, and that seems to distract from the merits of the case that's brought against these people.
Thank you for that. We'll have a presentation by Lisa now on the World Bank sanctions.
The fight against corruption is relatively new in our history. Part of the issue here is that mismanagement, bad management in projects is often disguised for corruption. So President Wolfensohn comes out in '96 and he says, cancer of corruption. This is taking a great toll on how funds are flowing from the treasury of the World Bank to the special account of the government, from the government's money to then the project implementing unit, and then monies that flow in a contract to a private company. Complaints come from anywhere. Could come from the press, could come from online, could come anonymously, could come by the telephone, could come usually from World Bank staff. Once the investigation does take place, there's a whole lot of stuff that goes on afterwards. The FIR refers to what's called a final investigative report, all internal. We could declare misprocurement, which essentially means the government has to give back the money. We can cancel funds. We can require action plans and integrity programs. We could then actually do what's called a referral report, and we pass it to a government. And then you move into the whole area of accusations and evidence, suspension and debarment, and really what is the meat of our discussion in sanctions. Thanks very much.
Thank you for that. So I'm going to ask Mark Di Carvalho to make his own comments as to his experiences as a corporate in countries such as India and others, and how they deal with it. And you also find things are changing in the recent past, or it's just continuing as it was?
I think the best way to understand the way American defence companies have gone about challenging or reacting to an anti-corruption environment is in actual fact to look at what happened to them many years ago. And in the 50s and 60s, we heard about geopolitical risks early on today. In the 50s and 60s, a lot of American defence companies went abroad to try and sell their hardware abroad in foreign markets, some of them emerging economies, some of them established democracies. And then in the mid-70s, that activity was put under the spotlight. It was put under the spotlight in what came under what's called the Church Committee. It was actually the Church Committees. There are a number of them. The Church Committee came out of a desire for the American government to look at the effect of foreign policy overseas, and a subset of that was the activity of multinationals and how they were conducting their business overseas. And it was there where the extent to which all American companies were partaking in bribery and anti-corruption activities, this light was shone on it, and the genie was out of the bottle. And about 10 years later, there was something called the Packard Commission. The Packard Commission was a look into defence procurement across America. A number of stories broke in the press on how these defence companies were just marking up these parts in planes and whatever and just passing it on to the Pentagon. That was looked at, found to be unsustainable, and they did change their ways. They got together, they bandied together, but it's those two sort of pieces of history that changed the way defence companies operated.
Mr. Sanchka is going to speak on development and action taken in Serbia and the West Balkan to tackle corruption, including criminal responsibility of legal entities, and we're very interested in hearing how that's done.
Thank you. When we spoke about corruption, we have several really legal questions what must be raised and discussed. First of all, is question of standing. Who has right to raise the claim? Is it each taxpayer or only prosecutor? On the opposite side, in corruption case, another legal question is who is the victim? When we're looking, let's say, FIFA case, we can to discuss like lawyers, who is independent, who is the victim in the FIFA case. So this is two main issues. When you compare with the company law, you have shareholders. Each of the shareholders has individual or derivative right to raise the claim. It's not the same in the corruption case. But at the end, somebody has benefit from the corruption. This is mostly legal entity. Is it legal entities can to be just vehicle, or can to be really third part or direct involvement part?
Thank you. Mr. Michael O'Kane, would you like to say a few words?
My own view is not enough is said about the checks and the brakes that are put on the initiatives to tackle global corruption. And the main checks and the main brakes, it seems to me, are, first of all, the lack of resources on tackling global corruption. The second and possibly most important brake, it seems to me, we all live in a very inconsistent world. That's one of the things that's so wonderful and interesting about it. But realpolitik is a major problem. In the context of tackling global corruption, what we have to try to do is get the standards of independence, the standards of ability, and the standards of excellence in relation to the application of rule of law as consistent as we possibly can across the global landscape.
Judge Zervos, if I may invite you to make some opening comments.
I think from my experience in Hong Kong, and I think the Hong Kong model is probably one of the best in the world, is that you need to have a specialist anti-corruption agency. And if you go for guidance to the United Nations Convention Against Corruption, it sets it all out, what is required. And you need to have a specialist body. Now in Hong Kong, we have the ICAC, Independent Commission Against Corruption. It consists of nearly 1,200 personnel dedicated to fight corruption for a population of 8 million people. You've got to tackle corruption by tackling it on both sides of the equation. And if you're not dealing with the private sector, you're really not focusing on probably where the major problem emerges in relation to corruption.
We're out of time. Thank you so much to a wonderful audience and to the panelists.
These are topics which all of us are facing. I'm personally from Canada, but our association is from around the world, and we're all facing these same challenges, so it's very timely to hear the discussions from different perspectives, primarily from an Indian perspective here, of course, but to see how our colleagues around the world deal with the issues we all face.
The conference brings together international delegates, even outside of Asia Pacific, to be able to share and exchange perspectives from all across the globe and bring them together and to refresh ideas and to reinvigorate people.
The conference has been great. I've been able to meet a lot of people from across a diverse range of companies and professions, and it's just been a great networking opportunity.
In the 5th edition of Legal Era's Gennext Counsel Congress and Awards 2016, eminent personalities from the legal business community from across the world discussed the challenges of setting up business in developing countries like India, UAE, and Africa.
What it is like for us in-house and what it is like when you're an outside counsel on doing business in difficult countries or challenging countries. Any thoughts or perspectives that the panel would like to share?
I think the first thing to recognize is what we consider to be a difficult region, what I prefer to call a frontier economy. And the fact that it's a frontier economy obviously means that the structures are weak, the institutions are weak. Therefore, in trying to set up business in that region, you have to be able to access the personalities who drive the entire system, rather than depend on the structure. So, if you're coming from Europe, you'll be accustomed to depending a lot on correspondences. Whereas, if you came to that region, you'll be looking to know the personalities. So, there must be a local experience that you combine with, such that you can access the business effectively.
I work with a Japanese law firm. We got 20 lawyers. I used to come to India once a month. We started Indian practice about 20 years ago. Now we specialize in that. I haven't been to India in 5 years now because we have 4 or 5 younger Japanese lawyers who do nothing but Indian investment work for Japanese corporations. Japan works on probably you've heard this, they work on a consensus basis. And there is a consensus that they have to invest, the Japanese companies have to invest in India. It's got the market here, and it's got the labor here. Japan is formed by a lot of technicians, people who came up through the ranks, and they were all engineers, you'd say. They would put things together, screw by screw, tighten down the screw, come back the next day, and continue their work. And that's exactly the way they handle legal matters, too. You draft a joint venture or a shareholders agreement or licensing agreement or anything, and they will work on it till late at night, and then they come back the next morning and start where they left off. The Indians, however, are universal thinkers. They would come back the next day, throw everything away, and start all over again. So, and the Japanese were flummoxed by this. This happened repeatedly. Well, this Japanese lawyer, though, he said this would never happen in Japan. If we had, and we make amendments to the law, gradual amendments, but they talk about it forever before they make the final decision or pass the law. And by the time they get down to the law, they pretty well have a very close consensus as to what this law means or the amendment to the law.
So I think, but the point is well made. I think in several countries, it depends on who you know, rather than what the law reads as. And I think India is a case in point where the law is laid down through statutes, amendments, circulars, rules, regulations, press notes, internal directives. And sometimes not easy to figure out for a third party what is actually the correct position. But clients coming into India, it is sometimes a huge challenge. And we can outline the risks, which are several. The potential profit seems to outweigh the risk normally. And I think as long as they know the hoops and loops they need to go through ultimately to get their profit out of the country and get their money out of the country, they go ahead.
Tobias, tell me about your experience in the Middle East and what you see. The Middle East is fairly similar in a sense, I must add, because you go to one government officer, you're not guaranteed to get the same answer when you go to the next.
Most of the problems will simply come from the fact that there are no regulations in place for this. So there are some general laws which govern the overall concept, but when it comes to how the authority deals with this and how the notary public, how you get an approval, then there is simply no regulation, meaning whoever you are dealing with decides on the spot what he wants to do with this. And you have no measure to appeal against this, so you have to find a solution.
Great. Greg, you've dealt with a lot of governments in different jurisdictions. Maybe how do you find contracting with government entities? Is this something that we need to have special provisions for or special skills?
Yeah, so Raytheon is a global defense company. We have over 65,000 employees worldwide and are active in many, many countries around the world. And in doing that, in each of those countries, we generally only have one customer. That being the government of the country that we're in. So it's very important to understand for each country, do they have a transparent way to convey what is important for them?
It's not just about finding out more, doing your homework, understanding the culture, but also then knowing people, knowing how to find different ways that are compliant to grow the business and deal with the challenges that we face locally. So I would say thank you all very much.
I think my experience attending this conference has been very good. First of all, we've had excellent people. I don't know how you managed to get such high quality of people from a variety of legal expertises into the same conference at the same time. Usually people are busy and you can't get them all together. And I think the way that the conference has been organized is also excellent. I mean, it's not only been very useful and interesting to be here, it's actually been a pleasure to participate and to be here. And we look forward to the events coming up, and I feel very positively about it.
The overall experience has been wonderful because you get to meet people from overseas who are some judges, corporates, the top leading corporates, and to exchange views with them. And some of them you've been meeting over the years, and so it's a wonderful networking opportunity, as also friendships are created and a huge amount of learning is exchanged.